Good morning, Ms. Eisenberg.
Good morning, Your Honors. Beth Eisenberg for Joel Rodriguez. This court granted further appellate review on our petition from the decision of the appeals court, and the chief claim challenges the admissibility and evidence against the defendant of a police officer's trial testimony in which he recounts a conversation he overheard between the defendant and a wired informant as a result of surreptitious, warrantless electronic interception of that conversation, which took place inside that apartment in which the informant was living with his wife.
Well, I suppose the real question here is whether cases that have followed blood have eroded what I think is, or what it seemed to me at the time, was blood's very broad language. Isn't that the main issue?
I do think that was something that was raised by the appeals court, but I do think that the cases that the court relied on were inapposite to the essential question of whether or not an individual in a private home.
Because Netto really didn't deal with it. And
Netto didn't deal with it. Collado dealt with a Fourth Amendment challenge to a videotape. There had been a warrant obtained for the audio portion of the videotape.
Okay, so then if we're left with blood as the governing principle.
Yes, and since blood, this court has engaged in, repeated reconnaissance over the borders of blood, really, and in doing so, over the past 20 years, I think that the cases show that the essential principle of blood has remained inviolate. If you look at, for example, the Ennis case in 2005, dealing with interception by correctional officers, or in Eason in 1998, which dealt with telephone interception, or the Penta case, which I think had to do with the sufficiency of the warrant, or Panetti, and in particular Feeney in 1988, which spoke of the magnitude of the unconstitutional intrusion into the home to intercept conversation as being so great that half measures of deterrence are not enough.
But don't you think the facts are very different in this case from blood?
No. And the reason I don't is because I think the essential elements in blood are all here in this case. You have a defendant who has no property interest in the place in which his conversation is being intercepted. He's a guest. He's an invitee.
He'd never been there before. He was just there for one purpose.
This is true. I mean, the evidence suggests that he has not been there before, and he's there for this purpose. But there's nothing in the parameters of blood that establishes that those factors play any part in whether or not an individual has an expectation of privacy that society is prepared to accept as reasonable.
I have a very basic question, and I just don't understand. In my reading of the statute, at least in the preamble, it talks about organized crime.
Yes.
Does it talk about organized crime anywhere in the body of the statute?
I think that if I am correct, I think that the discussion of organized crime or the reference to organized crime always takes the reader back to the definition of organized crime in the preamble.
But nobody talks. Then my question is this: is there a requirement in order to even get a warrant that there be a connection to organized crime? And as far as I could see, nobody mentions that.
In
this
blood.
case. No, in this case.
In this case. It wasn't an issue that was briefed, and it wasn't an issue that came up below. I think for purposes of what is what.
You mean because there wasn't a warrant, so it doesn't matter?
Yeah, exactly.
Okay.
And I think
Right.
what the problem here is that what we're really facing is whether or not the viability of blood will remain. And I think that the appeals court's decision was erroneous in two respects. First, as we've discussed, it purports to derive its reasoning from a body of cases for a proposition that they don't really stand for. Those cases don't clarify that a conversation in a private home is not automatically entitled to constitutional protection. In fact, as we've discussed, those cases really don't stand for that proposition. I also think that a panel of the appeals court, in essence, has made up an exception to a very carefully designed constitutional principle that was laid out by this court. And in doing so, it has abruptly shifted away from the philosophical underpinnings of Blood. And it's carved out an exception from Blood's holding that interjects into Article 14 analysis that has all the hallmarks of subsequent Fourth Amendment jurisprudence as it's evolved in the United States Supreme Court, particularly the case of Minnesota versus Carter, which was urged on the appeals court by the government. And the appeals court in its decision doesn't make reference to Carter, but it's the language and the reasoning of Carter that the appeals court appears to use in reaching its conclusion that this defendant had no reasonable expectation of privacy in the informant's apartment, as Justice Ireland had asked about.
Let's say for a moment that the informant was actually an undercover FBI agent or an undercover state police agent, and the apartment that he leased was totally set up with video cameras. It was a completely filmed nest where various people were invited who wanted to engage in illegal transactions. And this fellow came by to pick up a package. Do you think that would make a difference?
If the apartment was decked out with all kinds of surveillance equipment,
this is a
a
government-owned house.
And if the defendant knew that he was visiting someone who worked for the government?
No, I mean he's going to pick up a package at this house.
Yeah.
He's never been to the house before.
Yeah.
He's there simply to pick up a package of drugs. He goes in, he picks up the package, he's filmed because he's walking into an FBI-owned operation. And then he leaves. Do you think, or state police?
His conversation is recorded.
His conversation is recorded picking up the package.
Well, I think that there's more here to just the fact that this defendant came to an apartment he had never been in to pick up a package. The Blood decision talks about conversations in a private home are conferred an atmosphere of trust, or you look for that atmosphere of trust. And here in the evidence in this case, there was certainly evidence at trial that this defendant trusted this informant and that they were friends and that he engaged in a conversation with the informant in an atmosphere of trust. They had known one another socially for several months.
Is your, and I don't want to call it a quibble, I mean, I'm looking at the appeals court decision. He did not know where the homeowner lived, but they were neither close business associates nor close friends. I mean, is that the problem here?
Well, it is a problem because there's no language in Blood. And there are also strong open questions in Minnesota versus Carter that the intensity of a relationship isn't what defines the expectation.
No, it can't be, because I may be taken by you to a home of one of your friends. I don't know the person. You're taking me to meet, a school friend. I'm not a close friend. I'm not a close business associate.
Precisely. So that the intensity of the relationship is irrelevant. What this court has said, and indeed what 5 members of the United States Supreme Court said in Carter, was that almost all social guests should be afforded some rights of privacy, cognizable constitutional rights of privacy under the Fourth Amendment. And Blood says here, in Blood, the defendant Blood went into 2 separate homes. They weren't his homes. It's not clear how long they met for. It's not clear what his relationship was with any of these other people. It's never explicated in the case itself.
But Blood didn't seem to depend on that, at least my reading of Blood. It didn't depend on, it wasn't, the language in Blood wasn't fact-specific.
Right, because there is the essence of blood is that there is this automatic standing that is applied to an individual who comes into a private home to have a conversation. If that individual, now it's clear from the blood decision that we're talking about an invitee. It might be a very different analysis if blood had been a burglar, or it might be a very different analysis in some other kind of situation. But where you have either a licensee or an invitee, some kind of guest who enters the home with an expectation, as Justice Liaco said, that the ambit of his words, whether they're for licit or illicit purposes, whether it's to further some nefarious scheme or it's to foment revolution, those expectations are expectations which our Constitution has afforded unique and cherished
Ms. Eisenberg, let me
protections.
return, if I can, to
The notice issue?
no, to Justice Cordy's question. Another aspect of the appeals court's decision is, I think we have to give some meaning to the word private home. It can't be that if a building is in a residential neighborhood and could be a private home, but in fact isn't a private home. It's a business, right? It's the FBI's business office. There's nobody living there. They're just using it as a place to try to run an undercover sting operation. Are you saying that that the constitutional principle turns on whether the invitee believes that he or she is going to a private home?
No, you're saying
I-
just the opposite, that the facts don't matter, that there is, well, in a home.
Well, I'm just trying to focus
Well, I
on the
think
fact.
objectively, certainly in blood, there wasn't any question about whether they were going to a private home or not. And objectively, in this case, there wasn't any question that he was coming into a private home. The subtleties of whether an individual
Well, because we do have, we've said a motel, little different, right? And I think that what the appeals court is at least trying to do is to say, what happens if it's not? That's Justice Cordy's question. It's not a private home. And that's why I'm saying, do we look at whether it looks like a private home, it sounds like a private home, somebody thought they were going to a private home?
Well, I think so, because I think standing is the according of protections to a subjective expectation of privacy. And I think a subjective expectation of privacy has to be predicated on objective evidence that would reasonably lead that individual to subjectively believe themselves to be going to a home. I don't think it's a question that needs to be reached in this particular instance. I
Right.
think what the court is faced with here is the integrity of the blood decision, or whether or not this appeals court decision is going to stand as a breach to that otherwise inviolate body of law which has been developed over 20 years and which has been reiterated as inviolate.
I have a question on another subject. You raise an issue about the unanimity of the verdict.
Oh, yeah.
Forgetting whether you have to have unanimity on whether it's bringing in or intent to distribute, but the judge's instructions, and I went back and looked at the transcript, say that the jury had to be unanimous on either or both theories. Now, isn't that a little confusing? Either or both? What does that mean? You have to be unanimous on either or both.
Yes, I agree. It's confusing, and I think...
I don't think you did. You raise
Did
that?
I brief it? Are you
Did
asking
you raise
if I
that
briefed-
issue?
I don't recall, and I don't recall. I think what I did brief was the problem in the instructions themselves.
Right, that I read, but it hit me, it struck me that the either or both doesn't really say anything.
I may have. I did advert in the brief to problems facing the jury once the instructions were given, because the instructions were not, they encouraged the jury to adopt either of those theories of.
But we've
of-
never required that that there be unanimity on either theory under
but-
the drug statute.
Yes, that's true, but the problem here is that what this jury was facing, as I argued in that part of the brief, were two different theories, which were one which I said was not really supported by the law and which went beyond the requirements of the law, and because there was a request for a specific verdict, and it was properly objected to when that was denied.
Attorney Eisenberg, was there an objection made to this evidence at the time that it was offered?
This evidence, there is controversy about that. There was an objection made at sidebar as soon as defense counsel learned that there was going to be rebuttal evidence based on this warrantless interception, but the trial judge deferred that issue to another time.
Did trial counsel renew the objection?
Trial counsel did not. Immediately after that sidebar objection, trial counsel put on his case, and then the next day is when rebuttal evidence was presented. And I think in the press of trial, I would suggest that trial counsel did what we are all taught to do, which is to immediately object upon learning of the offer, the tender of evidence, which the attorney believes to be improper. And here I think he made all the right arguments. He said that he had gotten no notice, and he made timeliness arguments. So I would suggest that it's certainly preserved enough for that level of review.
Thank you, Ms. Eisenberg.
Thank you very much.
Mr. Townsend?
May it please the Court, Thomas Townsend for the Commonwealth. The issue, as the appeals court noted, is not preserved. At sidebar, defense counsel, when he heard of the potential rebuttal testimony, even before the defendant's case had begun, had objections primarily, if not exclusively, to a jailhouse conversation that had been recorded. The trial judge said she was only called counsel to sidebar for scheduling purposes. She was unprepared to rule on any substantive evidentiary grounds, and she urged defense counsel to renew the motion if he wanted to later. He promised that he would bring it up later. The next day, the rebuttal testimony came in without objection, probably because the rebuttal did not encompass the jailhouse conversation, which was the primary objection, if not the exclusive objection by defense counsel.
Do we know from the record what transcript defense counsel was referring to? Do we know from the record whether it was a transcript of a jailhouse conversation or a transcript of the eavesdropping conversation?
I think defense counsel, in a brief, assumes, I think is a proper assumption, that is of the jailhouse conversation, because when the trooper tried to record the conversation in the apartment, the volume setting was too low and there was no audible recording.
Is there anything in the record in this case that indicates that, one way or the other, that an eavesdropping warrant was obtained or not obtained?
I don't think there's anything in the record that says that there
it's
was a warrant
implicit,
that was
isn't it?
obtained. It was a
Isn't it?
warrantless. They had no reason to know. I don't know about the jailhouse conversation. I don't think we can determine on the record on that. But the apartment conversation, there was no warrant obtained because they didn't know there would be a conversation.
Now, I had one question in reading the briefs, and you just reminded me. The trooper in the car or outside the house, wherever he was, could he hear obviously he heard the conversation through the mechanical device, whatever it was. It was just that it was not recorded again.
Right, and
But he heard it.
He could hear it, and when he testified, and the appeals court characterized his testimony as sketchy at best, he heard bits of it, and he testified to bits of it, but he didn't testify to everything that could have been said. And the court, it found that there was no error, but then it went back and said, even if we assume there was error, there's no substantial risk of miscarriage of justice for two reasons. One, his testimony wasn't very convincing. It was sketchy at best. And two, it was largely cumulative and wasn't nearly as damaging as the other officers' testimony who had overheard the telephone conversation in which Mr. Toronto had called the defendant and said, your package is here, and the defendant expressed concern, is the package okay? Is everything okay? That was a more damaging rebuttal testimony.
Did the so-called informant, the man who received the package originally, did he testify at trial?
He did.
And did he testify to what this trooper, the conversation that the trooper would have overheard?
He did, and in much greater detail.
So that's another reason why it would be only cumulative.
That is
That's
correct.
why among other reasons, whether or not it's preserved error makes a difference.
Correct. And even if there was no preserved error under a substantial risk analysis.
Well, the substantial
that would
risk analysis
factor
is
in
not
also.
as, sure.
Going back to whether there was error, Article 14, like the Fourth Amendment, protects people, not places. And this court in Blood recognized that. Blood wasn't just a decision dealing with where a conversation took place. It dealt quite extensively with among who were speaking. And the underlying rationale of Blood is that among trusted friends, there's a sense of security. And due to that sense of security, that it's a sense of security that is essential to the liberty of thought, speech, and association.
But, Mr. Townsend, if you take me, I'm a friend of yours, right, and you take me to meet somebody that I've never met before, and then for whatever reason I remain there and you leave, I have a little bit of difficulty thinking that you have to have had a long, close relationship or trusted friend relationship. One looks at those circumstances a little differently.
Well, there's various considerations. It's not just where the site of the conversation occurred, where the defense
No,
counsel...
but a private home is certainly historically one of the key underpinnings, of what it was that the framers were trying to protect, was private homes.
Right. The relationship is one factor. The nature of the interaction is another factor, and that's why your hypothetical, you would have an expectation of privacy because it's a friendly, a friend had brought you to another friend's house. In other words, it wasn't a business transaction, which is a consideration that is developed in the case law. In contrary,
So we have a different standard for business transactions than for private conversations?
I think that's a consideration.
And
And
we
then
have
you
a
said, but if
different
we do,
standard.
what if the business person is a longtime friend?
Yeah, I mean, there
Well, then
was-
it's fact specific. That would have
gets into almost ridiculous distinctions.
Well, it would be ridiculous if we don't factor in the business considerations. Perhaps if a pizza boy had come and steps past the threshold of a home, under the defendant's argument, that pizza boy would have an expectation of privacy to the same degree as the homeowner would for the time that he remains there. And that's not something that I think this Court contemplates. It's certainly not something the Supreme Court contemplated. The key vote in the Minnesota versus Carter case was Justice Kennedy. He said most social guests have expectation of privacy in the homes of others. But he made a distinction. He said if it's a fleeting and insubstantial connection to the residence, that he would not afford an expectation of privacy. He gave a hypothetical.
Mr. Townsend, can I just ask you this question? Mr. Eisenberg has made an interesting point, and I hadn't thought about it, was that the appeals court, without referencing Minnesota against Carter, has essentially incorporated that jurisprudence into our Massachusetts Constitution. Is the appeals court's decision entirely consistent with Minnesota against Carter?
It is consistent. I wouldn't say that they incorporated it. The appeals court followed a line of cases, beginning with Blood, going through Price and Collado. And Price and Collado are relevant, as the appeals court found. Expectation of privacy is the same regardless of whether it's a Fourth Amendment or Article 14 analysis, regardless of whether we're dealing with audio or video surveillance. If someone has an expectation of privacy, they must have a subjective expectation of privacy that society is willing to recognize as relevant. It's the same analysis as if we were dealing with tangible drug evidence. If the defendant, when he picked up the bicycle package, a packet of drugs had fallen out, and unawares he walked out of the house, could he claim an expectation of privacy in this other man's residence? Actually, it was the other man's wife's residence, her bedroom. Could he claim an expectation of privacy to seek to suppress that evidence? I don't think so. Under Commonwealth versus Carter and like cases, the same analysis should apply here. He's going to the home of a person he doesn't know very well. He admits he doesn't know him very well on page 230 of the second volume.
You also say that he trusted, that they've had dealings before?
He was asked whether he trusted. And that's a problem with the factual underlay of this case. There was no motion to suppress. So there are some factual disparities. Mr. Tirado testified that he had known the defendant for 2 or 3 months, which is consistent with Mr. Tirado being released from jail in October. This happened in January. The defendant, on the other hand, says he knew him for 6 or 7 months. Well, that's a factual discrepancy that would need to be...
You say there was no motion to suppress, but I thought there was a motion to suppress related to different subjects.
Correct. There was no motion to suppress
But the issue,
based on this issue.
But the issue of this electronic overhear wasn't raised until the defendant indicated he was about to testify. So how was there going to be a motion to suppress at that point?
Well, under this court's case law, it need not be a motion. Well, it was never raised, period, before the judge, because when the time came for him to object and ask for a ruling from the judge, he did not. It was raised for the first time on appeal. And so we don't have we have no voir dire, we have no suppression hearing where a judge could sort through the facts in here. But I think the facts, as we have them, show that these were not trusted friends.
Is there any question that this attempt at recording was known to the defendant before trial?
I would think so. I would think he
Well,
got...
that's what I'm saying. Could it have been a subject of a motion to suppress if he didn't know about it?
I assume, no, that's the problem with the phrasing this for the first time with appeal. I assume they're all contained in the police reports which were furnished to the defendant.
But was there there wasn't a tape cassette, and there wasn't a sworn statement summarizing the conversation? I take it that, or was there?
We don't know. That's another problem. The defendant seeks exclusion for the first time on appeal under Section 9902, which requires, there's certain requirements. We have to furnish the defendant with either an audio cassette, a transcription, or a summary of a recorded statement. We don't know if that was done because he never raised it below.
In fact, we don't know what the police reports say, do we?
You would have
We
to
don't know.
automatically
We don't.
give that over if it existed, wouldn't you?
Under the statute, yes. And we don't know if we did or not.
You don't
What do you
know
mean
if
you don't
Well,
know?
we don't know based on this record if we did or didn't.
Well, I know, but,
This-
I mean, you're the prosecutor. Do you know?
I am the prosecutor, but I'm also dealing with the appellate record like this court is dealing with the appellate record. And under the Fleming decision, if the defendant does not raise this before the trial judge, he can't raise it for the first time on appeal as an afterthought. So that is a waived claim.
No, it may be a waived claim, but it would be helpful to know if, in fact, he had it. I
It
mean,
would
do you,
be,
do you
and-
know? Do you not know? You haven't looked at the police.
I don't
record?
have first-hand information.
Even
because
if it's
I
a
confine myself
waived
to the
claim, we
appellate
have to
record.
decide if there's a substantial risk.
Well, there's waived claims and there's waived claims. There's waived claims where there's enough to determine based on the record to make it intelligent ruling on whether there was a substantial risk of miscarriage of justice. And then there are waived claims where there's just not enough factual predicate to determine whether there was. And the appeals court
Well,
on
if we
Fleming
thought-
said you
if it-
have to waive it or you
Are you
can't.
suggesting if we think there is a substantial risk that we send it back for a hearing as to whether or not he got the information beforehand?
No, because if we jump to the substantial risk analysis, that was I would urge this court to follow the same analysis as the appeals court, and this is all cumulative. It wasn't very probative. It was.
Well, I take it your argument as to that is even if we disagree with the appeals court's reasoning, that you can then go down to its next paragraph, which the appeals court said, even if it concluded otherwise, you still don't, because this is all cumulative.
I could lose the battle and win the war, but I'd still want to win the battle because I think it's an important. Well, I think it is an important issue.
Well, it's entirely possible that at a hearing on a motion for new trial, a judge might be persuaded that it's newly discovered evidence.
And under Rule 30, the defendant can raise a motion for new trial at any time. So that's something perhaps he could do in the future. I would like to circle back and go back to Justice Kennedy's concurrence in Minnesota versus Carter, because I think he had an important hypothetical. He said that most social guests would have an expectation of privacy, but people with fleeting and insubstantial connection to a residence would not. And he gave the hypothetical of a drug delivery service where someone would go in with a pack of cocaine, drop it off, go into someone's residence, and leave the drugs there. And he says if the police had been present in the 19th residence out of 20 deliveries, or if they had seized the drugs afterwards, the defendant should not be able to claim an expectation of privacy in that residence. We sort of have the opposite here. Instead of going to deliver the drugs, the defendant went to pick up the drugs. He was only in there for a matter of minutes. He was only in there to retrieve this international drug shipment.
Except that he had a relationship with the person that might have permitted him to stay longer, maybe have a beer and sit around and talk. I mean, can't we consider those factors?
Well, if we look at the extent of the relationship, they didn't know each other very well. The defendant didn't even know where Mr. Toronto lived. He had never been to his address. He needed directions on how to get there.
But that doesn't make a difference.
Well, I think if he had visited the apartment earlier, previously, I think that would make a difference.
What if they had a long-standing relationship, but he had never, like at a place of employment, and he had been invited over to the man's house for the first time? Does he not have a reasonable expectation of privacy?
Well, those are all factors that I think need to be considered. Instead of just looking at the four walls of this home, and if it has four
But I don't
walls and a
think
roof
that
and someone
that's what
lives there, they have an
I
expectation.
don't think that that's a fair characterization of what the defendant is claiming here.
Well, the defendant is claiming expectation of privacy in a home, any
Based
home.
upon a relationship that he has with
Well,
an occupant of the home.
The defendant wouldn't even look at the relationship. The defendant would look to see whether it is a home and whether the defendant is present in a private home. The defendant makes no argument and, in fact, urges the court not to consider the extent of a relationship. And, in fact, the FAR application had to do with the appeals court considering the relationship and how that was improper. One wrinkle the appeals court did not address, and I'd like this court to consider, is that this was not Mr. Torado's home. This was his wife's home. The conversation took place in his wife's bedroom. He lived next door. He was released from jail in October. He had an attempt for reconciling with his wife. He was there just on a see how it goes basis. He kept this other apartment in reserve in case things didn't work out.
Do you really think a question such as whether a constitutional right to be free of an intercepted conversation is going to hinge on, should hinge on something like that?
It's a factor. It's a consideration. She had a roommate. The roommate had a young child. If all this conversation had taken place in the hallway, I think that would be a consideration. I think every time the defendant claims an expectation of privacy, it's fact-specific. We don't just look to see whether it was in a home. We look at the relationship between the parties, the nature of the communication, whether the party even had a
But then
claim
does
to
it
the
matter
residence.
whether the defendant knew that this wasn't his home?
Well, that would be one consideration under the subjective prong of the analysis. Under the objective prong of the analysis, it would have less weight. But all that needs to be considered. I don't think the defendant should be able to claim as much expectation of privacy in Miss Regan's bedroom as Miss Regan should be able to, especially when he had no relationship with her. He only knew her estranged husband. I would urge this court to adopt the reasoning and resolve of the appeals court.
Thank you, Mr.
Thank you.
Townsend.